Hello and welcome. My name is Todd Hutchison, and in this session I want to talk about giving evidence in court. A person is summoned to give evidence in court, and giving evidence in court is often referred to as testifying. You may be asked what you have been seen or what you've heard, and that event that pertains to a case, and you are able to say how it happened. This is called being a witness of fact. It basically is giving you an account of your experience. A person that is summoned to give evidence in court who chooses not to come to court, they actually refuse, may be served a subpoena. It is an offence to disobey a subpoena, and you may then be arrested and charged with contempt. See, courts can be a daunting place at the best of times and can bring on high levels of anxiety and stress. So some people don't want to go, or they don't want to give out their identity or be known to the person that's giving evidence. Sometimes we can use a scenario where the person's face doesn't have to be in the court, which means we're starting to use more technology. Now, you should get there early, know which courtroom you're attending, make sure the prosecutor is aware of your presence, and of course, dress appropriately. You must tell the truth when presenting evidence. Making a false statement is called perjury when it is a material matter of the case. Now, perjury is a very serious offence and can lead to probation, fines, or even a jail term. You'll be given evidence from a witness box, and the judge is to be referred to as Your Honour. You do not require to have a lawyer when you appear as a witness. You may be asked to make an affidavit before you attend the court, and this is simply a written statement of evidence that you as the witness has sworn or affirmed to be true. Generally, when giving evidence in court, you'll be asked questions by both the prosecution and the defence, and you may be subjected to cross-examination, which is another set of questions. You are required to answer those questions truthfully and completely. Make sure you speak clearly and calmly, even though all the stress is happening, and you can take your time. If you don't understand a question, you can ask them to repeat it, and try and be articulate in your responses. There are 3 key points I want to make. Firstly, the affidavit forms part of your evidence. So if it is adequate, you might be likely only asked a few questions. But if it has a lot of holes in it, they might be drilling you for some time. Secondly, you will not be asked your opinion, except on a matter that is common knowledge or where you are an expert witness. And lastly, you cannot generally be asked to give evidence that is inadmissible hearsay. So in summary, while appearing in court to give it evidence will likely feel like a high pressure activity, just be honest, answer the questions to the best of your ability. And lastly, make sure you've read your affidavit or any other evidence you are being questioned about so you're best prepared.